Good afternoon, students. Today's topic we will be discussing on the topic 3 of your syllabus, that is the Hindu marriage, its essentials and void, valid and voidable marriage. To begin with, if we talk about, marriage is one of the, it is the bond, or it is considered to be the nucleus of the family. It's a process through which a physical union of a man and a woman it is the physical union of a man and woman which is legalized for thereby regulating the social life. Basically, if we talk about marriage is considered to be a sacramental in the mode of Hindu law. Further, in the in the case of Gulpili Soria Raj versus Bandaru Pavani 2009, it was being considered that Hindu Marriage Act 1955 has laid down necessary conditions and necessary condition, and it was being opined by the court that the first and foremost condition of a Hindu marriage is that both the parties has to be a Hindu. And further, it was also, and thereby enunciated the importance of section 5 of the Hindu law. According to the Ernest R. Grooves we talk about, he opined that it is a public confession and legal registration for the adventure in the fellowship. If we talk about the to be precise, the nature of Hindu marriage, the first thing that comes under is whether it's a civil or contractual or sacrosanct. Under the Hindu law, it is the main object of the Hindu law is actually for for performance and for enabling or begetting a child, or who for enhancement of a society. In the original significance, Hindu marriage is considered to be a sacramental or sacrosanct, but as there is certain legislation making the provision of dissolution of marriages, it is gradually has given the shape into the form of contract. Further, it can also be said that it is both sacrament and civil contractual, because because if we talk about sacramental, it is an eternal bond, it is a holy union, permanent and indissoluble union. Further, if we talk about the civil one, it is because of the part that it with the insertion of Hindu Marriage Act, the and especially the section 13 and 13b has made the entire law contractual as well as sacramental in nature. If we talk about the next is what we need to understand. The relevant cases under this, the one of the first most important one is Bhagwati Saran Singh judgment, wherein the court has opined that Hindu marriage is not only a sacramental but also contractual. Further, in Anjani Dasi versus Ghosh, the Calcutta High Court also has opined that suits relating to marriage dealing with that which is the eyes of law must be treated as civil contract and with important civil rights arising out of the contract. And finally, the marriage is also sacramental and it must be eternal. This view was also being liberalized in 1856 by the passing of Hindu Widow Remarriage Act. So thereby it can be concluded that Hindu marriage is both sacramental and contractual. Now, the forms of marriage, if we talk about, there are two types of, or two forms. The first one is the regular approved, and the second is irregular or unapproved. In regular, we have the Brahma, Daiva, Arsha, and Prajapati. And irregular, we have Asura, Gandharva, Rakshasa, and Pisacha. Brahma, if it is talk about, in this form, bride's father invites the bridegroom and make a gift of his daughter. It is especially the person to whom the such kind of the daughter is given is considered to be a learning man or learned man of Vedas. In Daiva, in this form, actually, the bride decked with ornaments and is given to a priest who duly officiates at a sacrifice performed by the father in lieu of any dakshina or any fees. So it is basically an exchange of any kind of fees to the priest. So basically, the bride is given in exchange of a sacrifice or a kind of dakshina or a fees paid to the priest. Arsha is another form where bride father accepts one or two pair of the crowns from bridegroom in exchange from the bride exchange of the bride. In the Arsha, the nominal character of the sale is very much clear. So the father's taking from the bridegroom a cow or a bull in lieu of the bride is it shows the nominal exchanging mode. Prajapati again here, the father addresses the bride couple and gives as a gift to the bridegroom, not invitee but a suitor. Prajapati in ancient is almost similar to the Brahma form of marriage. If you talk about the Asura in the first unapproved, here we can see that the bridegroom receives bride by paying money. And according to Manu, when the bridegroom receives as a maiden after having all the wealth as he can afford, according to here, the bride can be treated according to according to his own will. So the groom can treat in anyhow with the bride. Gandharva, it is a kind of love marriage, even though Gandharva is like where the man marries after the mutual agreement with the wife. But however, this is considered to be one of the most approved, most approved in today's society. Rakshasa, it is a forcible marriage against the will, and Pisacha, where the man seduces the girl in sleeping or in unconscious mode. However, section 7 of the Hindu marriage talks about the different kind of marriage have ceased to exist, and now the parties can adopt any one of the marriage prevailing in the community. Moving on to the main important is the conditions of marriage. As per the old law, it is the identification of caste, monogamy, sapinda, prohibited of sagotra and saparva, degrees of relation, manner of ceremony. But instead of the old law, we are much more prevalent to under section 5 of the conditions of the Hindu marriage, and it is considered also the most important validity of a Hindu marriage. The first is monogamy, means having one spouse. So especially you cannot consider to have a bigamous relationship. This is particularly, again, if he is doing against, again, he's having a second wife, then he will be charged guilty of bigamous marriage under section 70, and such marriage will be declared as void under section 11. Further, bigamy is also liable under 494 and 495 IPC. The second is the mental capacity, where at the time of the party, neither of the party is incapable of giving if he is incapable of giving the valid consent, then such will not be considered to be a valid marriage. Further, in this particular consent, in this particular 5.2 talks about the word free consent, and this free consent, it also means having the mental disorder. If you are having a mental disorder, of course you cannot be in a position to have a free consent. And further, this is also considered to be avoidable marriage under the section 12(1)(b). Age of the parties, that is the majority, that the marriage should not be within the minors but should have a minimum standard of majority ages. Even though in the Vedic era, a boy and a girl on attaining of the puberty would have considered to be was considered to be the marriage within a child marriage or a marriage. The minor marriage were considered to be a valid one, especially if the girl being 10 and the boy being 15. But nowadays, post this Child Marriage Restraint Act has passed, such kind of child marriage has totally been restrained. Further, it is also, the option of puberty. The bride can exercise the option of puberty in case under the customized law, the girl has been forced to get married, then she can repudiate her marriage as per section 13(2) under the decree of divorce on attaining the majority. Further, 5.3, if we talk about, it also enhances, we can see several judgments has been passed on, enhancing and uplifting the development of 5.3. Prohibited is again is one of the major concern, which is talking about that within the degree of prohibited relationship is customized. By custom is totally not allowed. 5.4 is talking if there is any custom of usage governing the contracting parties sanctioning such a marriage, it would validate the marriage, and the voidability of the same prescribed section 11 of the act will not be coming into play. So basically, here in Hindu law, we can see there is an amalgamation of both custom and, of course, the law. So where there is custom is entertaining, where there is a custom, the law cannot intervene or interpret it over there. The next important, if we talk about, is the 5.5. If we talk about any marriage that is being solemnized under section 5.5 will be considered to be void to section 11. That is, any person who procures such marriage shall be punishable. That is the Sapinda relationship. Sapinda is that having the same lineage. So usually under Hindu law, it is not allowed. Further, Hindu law also gives talks about the marriage ceremonies mentioned in section 7, registration 8, and of course free consent. Even though section 7 and 8 we have already discussed, but free consent under this particular slide is one of the very most important thing, because free consent coming in section 14 talks about that no marriage can happen out of any coercion or undue interferences or fraud as per section 14 of Indian contract. So basically that particular definition is also applied in Hindu law. So no marriage will be considered to be a valid one if such has been obtained out of undue influence, fraud, or any kind of mistake or misrepresentation. In this per se, we need to understand the doctrine of factum valid, which is originally originated from the Roman law, that is factum valid quoth fide debot, which means that what ought not to be done is valid when done. So basically, when hundred of text and any kind of legal practices, any kind of practice which previously was not being practiced, but once it started practicing, one started following from generation after generation to a decade, such a doctrine or such practice starts to be becoming valid. So that is where the doctrine of valid has been applied for the validity of marriage. Either it is irregularity or performed in disregard to the Hindu law text, where are merely directory. Further, in Venkatanamma versus State, the Andhra Pradesh court has applied the doctrine of valid to a child marriage and held that marriage itself is valid, though penal consequences are attracted. Therefore, child marriage are neither void nor voidable. So basically, since the child marriage, as per keeping in mind section 5 clause 4, if there is a custom prevailing, of course Hindu law cannot intervene. So keeping in mind of that, the court has also given this particular such kind of statute or such kind of sanctimum laws under the doctrine of factum valid. So that was all for this session. I hope you have understand, but however, if you haven't understood any of the part, or you can write to me, or you can mail me, and I will be in a situation to, I will be glad to answer your queries, clarify your queries. So thank you so much and have a nice day.